first of all. And if you're going to ask it as a comparative question, then it's a political question. It's not a legal question.
It's a question of race.
But
You've had Europeans in South Africa
that's
for
fine.
centuries who have committed atrocities against people.
I'm not going to.
Now Saddam Hussein allegedly did the same thing.
There's no way I'm going to. I'm not going to argue one bit with you on any of the statements you're making. But those are political statements.
Next question.
Okay. I've noticed that there was an interesting choice of language among the three of you in that, you have a defense attorney using the term accuser and a prosecutor using the term victim. When in court or in the media, do you think it's appropriate to use either term or neither term, like alleged victim or something else?
Are you a 1L?
I'm actually a freshman undergraduate.
Oh, okay. Okay.
Most of the time in court, we will get a routine motion from defense counsel, and we cannot use victim. We can say alleged victim. And certainly the newspapers do that, and we do that, because people are innocent until proven guilty. And so a victim, although there are some, sometimes it's not, someone is a victim, it may just be a question of who did it. But it's, even so in court, we don't use victim without an adjective in front.
And you know what's very interesting in terms of reflecting the media's perception on the Michael Jackson case is, I heard more people refer to this boy as the accuser than I have in almost any other case. In almost every other case, it seems that the media is bending over backwards to call the person the alleged victim, which suggests a level of truth in the allegation, even if you call it alleged. In this case, and again, this further, I think, supports the point I was making before, which is that Michael Jackson got as fair a shake from the media as I've seen any high-profile defendant get, is that the boy was constantly referred to as the accuser in this case, more than I've seen in any other case.
Drew?
First of all, thank you for coming tonight. It's been really enlightening to hear your comments. Producing for cable TV, I actually found your comments quite interesting on how a lot of people attack the media, even though I'm glad that the media fosters the truth and giving the truth to the public. But my question is posed to the two lawyers in the room. And my question for you is, having had all the experience and knowledge that you have practicing for this long period that you have, what is one thing that you wish you had learned while you were in law school that you know now?
You're older than me, Tom. You can take that first. Back to you.
I wish I had emphasized trial practice more. I think it's not right that people graduate from medical school and they can't operate in a life or death situation without real hands-on training, yet people get out of law school and people's lives are in their hands and they don't know the first thing about trying a case. I think that's wrong. I think there are too many guinea pigs out there for lawyers who just don't know what they're doing in the trial courts, because someone can go to prison for the rest of their life, someone can be executed, someone can lose all their assets, which can destroy their family because a lawyer is not skilled, is not experienced, and we just don't require that as a ticket for trying cases. So I think the legal profession needs to realize that trying cases is no different than a doctor operating.
Any quick comments, Martha?
And the corollary to that is, on the public side, people have to pay for it, because we don't want to pay our prosecutors, we don't want to pay our defense counsel, and then we wonder why we have mistakes and wrongful convictions. And the medical analogy is apt, because if we underfunded our medical health system the way we do our criminal justice system, you'd have a lot of autopsies with people who died because people weren't skilled. However, the one thing that is true is, and Tom would agree with me, I think, there's just no substitute for experience. You could be in law school for 6 years, but if you're not putting juries in the box, doing that witness, getting feedback from people, and that's why watching yourself do stuff is helpful, but getting feedback, you can't do it unless you do it.
I'm going to take all three of the last questions at once and then get one answer. So once you all come up to the microphones.
Thank you for coming.
A little closer.
Excuse me. Thank you for coming, Mr. Mesereau. But I'm going to articulate what you first started when you first started speaking about racism being applied to individuals around the board in America. And I'm going to take you back in this state right here in 1738. A case by the name of Massachusetts Bay Colony versus Henry Negro James, Bodies and Strangers in Plain View. Do you remember that case when you was a student here? Because I've never been in law school in my life, and I know the case almost in its entirety, and every time I ask for a copy in this state, no one's heard of the case. No one's heard of that case. But I found that case in the law library at MCI Walpole back in 1979, and I left it with some individuals there, and I haven't been able to find them, because I can shepherdize any case that I've seen in front of me, and I don't have any legal practice. And I just cannot find that case. And my second question is, I can't understand why that when in Massachusetts, the trial attorneys, and I've had this conversation with Mr. Stephen Sack, who is a very renowned attorney here, and we speak briefly a lot on different cases. And there are a lot of cases in this state where attorneys are very quick to plea bargain, especially when they have all the information that can lead them to more than just the gist of why an individual is being tried. They don't even want to try the case, and she almost spoke about it a little while ago. But the attorneys in this state here, I don't even want an attorney if it's not Stephen Sack or Mr. Maxwell Stern, because those are the two individuals I have any faith in. And it's really sad that the jurisprudence in this state here is like it don't even exist for an individual to get a fair trial, because I believe there's no such thing as justice, because the Constitution relegates that when it speaks about it. And I'm from St. Louis, Missouri, and I do know about the case of United States versus Mr. Monroe. I can't remember the citation right now, but it'll come back to me in a little while, right? But the individual was a slave individual, and his ownership was transferred. Dred Scott versus Dred Scott. Yeah. And Missouri. I can remember cases like that which transcends anything Michael Jackson would ever want to be a witness to or a victim to.
Okay, now Mr. Jones and Mr. Cook, last question. So the one's about 1738 Mass Bay Colony, and I've got 3 people who are going to research that and get the answer.
Good.
Right? And laptops. They'll find it. Mr. Jones and Mr. Cook.
I'd like to kind of attach to what my brother was saying. In the sense that I'm one of the students who is under the tutelage of Professor Ogletree in the Criminal Justice Institute. But one of the issues that comes up for me listening here and every day at CJI is how do you arrive at your version of the truth? Did there come a time when you sat across the table from Michael Jackson and said, Mike, did you do it? Or did you look at the evidence in whole and come to a conclusion there? Which is, I mean, I'm not making a normative judgment either way, but it's a question also across the other side of the table at the prosecution, because as I watch at Roxbury, everything is so rushed, everything is so hurried, and the system's just chugging right along. How do you, as a prosecutor, arrive at the truth? Do you ask the victim broader questions besides what specifically happened at this moment, or do you really try to get a bigger picture and try to do justice with a broader sense of truth?
Okay, Mr. Cook.
Good evening, Mr. Mesereau and Dan and Ms. Cokeley. I wanted to ask a question of Mr. Mesereau, and I also wanted to ask a question of Mr. Abrams. In the case of Michael Jackson, we realized that cameras were not allowed in the courtroom. In general, I'd like to know what your disposition is toward having a trial, especially high-profile trials of this nature, what your position or perspective is on cameras in the courtroom. The comments that you've made about the Michael Jackson case in respect to race are interesting, and I think that you have provided an apt and sophisticated perspective on how you handled the racial issues from that vantage point. But one of the concerns that I think a lot of black people have had, and certainly the thoughts that I've had in looking at the Michael Jackson phenomenon, is that Michael Jackson is an eccentric type of person, or he has characteristics or behavioral aspects of his personality that are apparently considered eccentric. And it seems to me that the media has highlighted those supposed eccentricities and made him look like a buffoon and a fool. And to me, there is a racial element there, because I think Michael Jackson is one of the very few high-profile black people that we've grown up with who is more or less an artistic eccentric. But on the other hand, there are many wealthy, artistic white people that are well known who are also eccentrics. And so I'd like you to comment a little bit about that aspect of it. I think the media has exploited this, and I think there is a racial element in the sense that his eccentricities are no more bizarre than that of many other white artistic personalities. Mr. Abrams, you have, in your defense of the criticisms of Mr. Mesereau of the performance of the media in the Michael Jackson case, have, sort of suggested that it was more balanced there than there was. And you pointed out that Geraldo Rivera, as an example, shows some balance. But I would really ask you if you could cite 3 or 4 other personalities that were out there in this case that appeared to defend the defense side of the case. And
that's balance, right? Just so we're clear, balance from your perspective
I'm
is
talking about
defending the defense
balance
case.
in terms of the
is advocating Michael Jackson's position.
And secondly, in your personal opinion, were you unaware of information that would have had a more exculpatory impact in Michael's benefit, and some of the points that Mr. Mesereau mentioned about that? I would like some comments on those things.
Final question, then we're going to get one answer. I've got the 5 points. Here's the last one.
Okay. Actually, I just want to say that I'm not a law student. I'm just representing the Michael Jackson fan community online. And I was going to add to what he said about the race card being played. I think that we were really blessed to have the jury on our side. And I think even if you wanted to, you couldn't have played. I mean, if you did find that there was a component of race, I don't know how effective it would have been for you to actually go out and say that, because like he was saying, the media has propagated this image that Michael Jackson is not an African American, or he's disowned his race, and they've, just changed this whole vitiligo into this, skin bleaching thing. So even if you had gone out and said that there is a component of race, I don't think it would have been effective, because most people just, look at him and they say, oh, he's a white guy, he doesn't, own his race. So that's something I want you to react to. And
okay, we're going to have to stop there. We've got just a couple minutes for responses. The first question was about plea bargaining, whether or not it's good for the system. The other is the search for the truth from the prosecutor and the defense point of view. Cameras in the courtroom, and then the issue of race in the Michael Jackson case. Martha, which one of those you'd like to take?
I'll take search for the truth for the victim. My practice has been I need to believe the victim myself, and I need to feel at least reasonably certain that we can prove that case beyond a reasonable doubt. We've had tons of victims, particularly kids, sometimes young women, sometimes young men who've been sexually assaulted. I believe them, but a jury isn't, because there's not enough evidence, or they were intoxicated, or there's contradictory evidence out there, and it's just not going to work. So I'm realistic about, before I put people through a trial, what the odds are, and I'm not going to put a 6-year-old or 7-year-old through a trial if I don't think there's a reasonable chance that there will be success there. It's not fair. There are cases where we just have a victim's testimony, and we go with that. But if you don't believe the victim, if you as a prosecutor do not believe the victim, nobody else is going to, and you need to know that. And it's important for me. Defense has a different job. Defense is to make sure we do our job. Our job is to make sure that we bring charges that we believe in and prove beyond a reasonable doubt. And that's different than what a defense lawyer does, I believe. So I think we have a different and a higher obligation not to bring cases that we don't believe the victims are telling the truth, and we can prove it. Now, I will say that we don't always know that. I mean, sometimes you say, I believe the victim, but I don't know, but then I'm not the truth finder, and that's why we have an adversarial system. But my experience has been, if I have doubts